A man was tased and shot in Florida, this time by a police officer. Was the officer justified? Let's talk about it. Hello, my name is attorney Rachel Moss with Attorneys for Freedom, and today we're going to dive into a legal analysis about an officer-involved shooting in Charlotte County, Florida. Now, this shooting involved Officer Timothy Poole, and the deceased is named Daniel Birch. He was a 50-year-old man living in Charlotte County, Florida. Now, this day, the officers responded to Mr. Birch's home after a neighbor complained. The neighbor first called 911 earlier in the day, alleging that Mr. Birch had caused some damage to his property. Officers responded, reviewed the scene, and determined that there was no evidence. However, they did document the incident. Later in the day, the neighbor called again, this time alleging that Mr. Birch had assaulted him at a nearby club. So, officers responded to the scene and decided to meet up with Mr. Birch. With that being said, let's dive into the video.
It's 5:11. I just got home. I still got to take a shower. I won't be over at the golf course for about an hour. And here she's calling back.
Give me some. What's up?
You tell me.
I tell you what, if you guys want to cross your T's, go ahead and cross your T's and dot your I's.
So here so far, we've seen the officer speaking with the neighbor who reported the incident. Now we see Mr. Birch walking up and starting to engage the officer.
Let's do it.
Let's do what?
Do whatever you need to do, because I'm tired of you showing up at my fucking house.
I haven't been to your house.
This guy's a fucking alcoholic. He's down there at the golf course.
Okay.
So let's do it or not do it. What are we gonna do?
What are you threatening?
Do it or not do it.
Are you threatening?
Do it or not do it.
Did you clean up the lamp?
Come on. Come on.
Oh, go back to your apartment.
Do it. Do it. Come on. Yeah.
Oh, come on, motherfucker.
Why?
Come on, motherfucker.
Why are you fucking lasering me?
Because you were already trying to hit me.
I didn't try to hit you.
Yeah, you're moving up on me.
So now I'm bleeding. So now I'm bleeding, and you're doing all
310
this.
Central. Go ahead and send me back up. Subject tried to attack me. Got him at gunpoint right now. You need to get down on your knees.
I haven't done anything wrong.
Get on your knees now.
I haven't done anything wrong.
Shots fired. Shots fired.
From this point in the video, we then see the deputy move into the home to provide aid to Mr. Birch. So Mr. Birch ended up passing away about 2 days later. So there's a couple things in this video that we need to break down. The first part is that initial confrontation when the officer decides to tase Mr. Birch. Then later on in the video, obviously, when the deputy then proceeds to shoot and kill Mr. Birch. So let's go over that first part of the incident once again. So as we can see here, the officer first starts by going to the neighbor, gathering a police report, doing his job after receiving a call from 911. Then we see Mr. Birch start to intervene. So like in many situations, there's never quite a black and white of who's right, who's wrong. Often both parties do some things that aren't so great. So right off the bat, I'm going to say it wasn't great for Mr. Birch to intervene when the officer was just trying to do his job. He should have let the officer gather his report. He should have let the neighbor say his piece to the officer and then talk to his neighbor later on, talk to the officer later on if he wanted to. Now, am I saying that means Mr. Birch deserved to be shot or tased? Absolutely not. But I am saying Mr. Birch probably should have stood back during this part of the confrontation. So next we see Mr. Birch coming up and starting to make some statements that do sound like he's attempting to bait his neighbor. He's repeatedly saying, do it or don't do it. Do it or don't do it. He even makes a gesture at his neighbor, almost as if to say, come here, almost as if he wants his neighbor to fight him. To me, it seems pretty clear that Mr. Birch was trying to start something here. However, he was just saying mere words. He wasn't actually doing any sort of action that indicated that he was about to hurt either his neighbor or the officer. He wasn't raising his fist. He wasn't really stepping closer to the neighbor. He wasn't stepping closer to the deputy. He wasn't grabbing a weapon. He wasn't looking like he was about to charge at them. He was standing in one spot saying this. And then during this is when the officer decides to take action and pull out his taser. Now, Mr. Birch clearly sees that the officer is getting ready to do something, and he says, "Do it," at the officer. So now an officer doesn't have to listen to a citizen just because they tell them to do something. In this same instance, an officer doesn't really have a pass to taser someone just because someone's telling them to do so. In fact, this should be a clue to an officer that maybe this person isn't mentally where they're supposed to be in an instance like this. Maybe this is a signal for an officer to call in backup, that they might need some help for a call like this. Maybe this is an officer's sign that they should start trying to de-escalate the situation with other techniques rather than escalate by pointing a taser at someone. Now, an officer should always be acting to protect themselves. They should not do anything that's going to put themselves in harm's way. An officer doesn't have to take de-escalating action if it means they're more likely to get injured, if it's something that might prevent them from getting home to their family at the end of the night. So I'm not saying an officer needs to do this. However, this is an instance where I do not think the officer was justified in pulling out his taser. I did not see how the officer's decision to tase Mr. Birch was beneficial to that situation. It did not seem to be protecting either the neighbor or the officer from bodily harm. I think it's time to dive into Florida statute about law enforcement. So we're going to be looking at statute 776.05. So to read it out, it just says a law enforcement officer or any person whom the officer is summoned or directed to assist him or her need not retreat or desist from efforts to make a lawful arrest because of resistance or threatened resistance to the arrest. The officer is justified in the use of any force which he or she reasonably believes to be necessary to defend himself or herself or another from bodily harm while making the arrest. Now, there's a couple things to consider here. We don't know if this officer was actually attempting to place Mr. Birch under arrest or not. It's possible at this time that the officer had gathered enough information from the neighbor to make that decision to make an arrest, but we don't necessarily know that. At this time, it does appear the officer was not attempting to make arrest, but was just attempting to potentially defend himself from an escalating situation. So, it's questionable if this statute comes into play or not. So let's compare this to Florida's regular use of force statute. So Florida's use of force statute is found under 776.012. It says a person is justified in using or threatening to use force, except deadly force, against another when and to the extent that the person reasonably believes that such conduct is necessary to defend himself or herself or another against the other's imminent use of unlawful force. A person who uses or threatens to use force in accordance with this subsection does not have a duty to retreat before using or threatening to use such force. So, if this is the statute applying in this situation, the officer does not have a duty to retreat. But just because you do not have a duty to retreat does not mean that you then have permission to do whatever you want. You still have to be reasonable, you still need to be facing an imminent threat, and your force still has to be proportional. I think when you have a taser, it's something you can argue is ordinary physical force. It's something you can also argue is deadly physical force because it's capable of causing serious physical injury. So let's look at that section of the statute regarding deadly physical force. It says a person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or herself or another, or to prevent the imminent commission of a forcible felony. A person who uses or threatens to use deadly force in accordance with this subsection does not have a duty to retreat, has the right to stand his or her ground if the person using or threatening to use the deadly force is not engaged in a criminal activity and is in a place where he or she has a right to be. So this section's very similar to the ordinary force section. Here, we're just dealing with deadly physical force. So whether or not we're considering the officer's use of the taser ordinary or deadly physical force, the same things still apply. There still needs to be a reasonable action, there still needs to be an imminent threat, and there still needs to be proportionate action by the officer. Now, looking at each of those boxes, let's say, is he facing an imminent threat? When I look at this video, I don't think so. All we had here were mere words, and mere words are not enough to justify a use of force. You need mere words plus something else. Here, that wasn't present. It did not appear that Mr. Birch was moving at the officer in any way. Second, was it proportionate? Here, Mr. Birch had no weapon in his hands, so if we're considering this deadly physical force, it's even less likely that the officer was justified. Because Mr. Birch had no weapon, it did not look like he had his fist up, he wasn't attempting to punch or harm the officer or the neighbor, it's very unlikely that we could argue that Mr. Birch was about to inflict deadly physical force upon the officer or the neighbor. And was it reasonable? I don't think so. So in a situation like this, I would say the officer was not justified in inflicting this sort of force against Mr. Birch. However, the video goes on a little bit more. We see Mr. Birch begin to somewhat fight back as the officer is doing this. He starts to swat at the wires after the taser is deployed, but eventually Mr. Birch backs up towards his home. We can see that Mr. Birch does have some bleeding at this time caused from the taser. Now, this is where I think it gets a little more debatable when we get into whether or not the officer was justified in firing shots. So let's watch that portion of the video again.
You need to get down on your knees.
I haven't done anything wrong.
Get on your knees now.
So I want to pause right there because you might have noticed Mr. Birch pushes the firearm out of the way. So the officer has decided to raise his firearm, pointed at Mr. Birch, and Mr. Birch swats the firearm out of the way. It seems like he might be attempting to grab the firearm as well. Now, this is something really dangerous. If Mr. Birch was to be grabbing the firearm out of the officer's hands, this could be dangerous. This is a situation where the officer then could be facing deadly physical force himself. So in a situation like this, let's say it started from this incident where the officer pulls the firearm and the man pushes it out of the way. This is a situation where the officer might be justified in firing a shot, especially if the officer argues that he was attempting to place Mr. Birch under arrest. Because again, in contrast to the statute we just reviewed, if we go back to 776.05, remember it says the officer is justified in the use of any force. So that means deadly physical force or ordinary physical force. When an officer is attempting to effectuate an arrest, we no longer have that proportionality requirement that we have for a regular self-defense or defense of others statute in Florida. So it's really interesting here. If the officer makes that argument that he's attempting an arrest, his actions throughout this incident become a lot more justifiable. Because here, we can still look at Mr. Birch and say, well, maybe him pushing the firearm or grabbing the firearm isn't deadly physical force. He's using his hands. Him and the officer might be about the same size. It's hard to tell in the video. But we could argue that it's not likely Mr. Birch was able to exercise deadly physical force here. However, if 776.05 is asserted, it doesn't matter. The officer is allowed to use any force. The only qualifier is that he believes is reasonably necessary to defend himself or another from bodily harm. That's the only standard. Again, this is a lot different than the self-defense statute. He doesn't have to defend himself from great bodily harm, which is normally what is required for deadly physical force. Here, it's just bodily harm. That's a very low standard. A little scratch on your finger could be bodily harm. Someone hitting you and it just hurting, you could argue that that's bodily harm. So here, if the officer takes this approach in defending himself, he has a much more justified case. However, the video goes on after Mr. Birch does this. We can see after that initial grab at the gun, the officer takes a few steps back. This isn't too uncommon. We often see officers do this as it's part of their training. But after he steps back, there are a couple seconds that go by. And you can clearly see Mr. Birch is standing there. He does not appear to be making any movement towards the officer. He still does not have a weapon in his hands. And he's not making any threats towards the officer. He is just standing there. However, I acknowledge that this situation is moving fast. It's just a couple of seconds. So, was it enough time for the officer to really have a break in the action? It's a little debatable here, and this is why I always say these cases come down to reasonableness. I can give my legal opinion about what might happen, but at the end of the day, if this goes to trial, a jury gets to make the decision. And jury members often have different ideas of what is reasonable and what is not. So one person might say, well, Mr. Birch is still an imminent threat to this officer. Even if the officer's backed up a little bit, he just proved that he tried to grab a gun from him. Another person might say, Mr. Birch is no physical threat. He has no weapon here. Another thing to consider is the officer, we could argue, is potentially the initial aggressor here. He was the one that aggressed when Mr. Birch was just standing there. He was the one that deployed the taser. So here we could argue the officer is the initial aggressor. He was the one who deployed the taser when Mr. Birch was just standing there. Mr. Birch then attempted to defend himself in what I might say is a proportional way. He tried to swat the wires off of his body, maybe swatting at the officer a bit, but it's a little hard to tell when that action is ongoing. Then he backs away from the officer. The officer's the one who points the gun at him, even escalating the force at this point. And then Mr. Birch tries to move the gun out of his face. Again, something we could argue is, again, proportionate, even if he is attempting to grab the gun. However, because this is an officer, once again, everything is a little trickier than it would otherwise be. If this was just two individuals, it would be a much clearer case. But because we don't know exactly what the officer is trying to do, it becomes a little more difficult to make our assessment. There's another statute I wanted to look at here. I wanted to look next at 776.051. Let's read it together. A person is not justified in the use or threatened use of force to resist an arrest by a law enforcement officer or to resist a law enforcement officer who is engaged in the execution of a legal duty. If the law enforcement officer was acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. So we have to take everything we're seeing in the context of this statute. So where normally, if you're facing just another person on the street, let's say if this whole confrontation had gone down between Mr. Birch and his neighbor, it might be another story. Because here, Mr. Birch doesn't have to be concerned if he's resisting an officer's lawful action. And here, remember the standard is if the law enforcement officer was acting in good faith. Now, if I was the officer's attorney, I would definitely be arguing that this whole incident was in good faith. I would say from the beginning, Mr. Birch approached the scene very aggressively. He was attempting to instigate a fight with his neighbor. He did move a little bit closer throughout the incident. In my opinion, at the time the officer deployed the taser, Mr. Birch was no longer moving closer. The officer might say he perceived a movement or it looked like Mr. Birch was still coming closer at that time. So I think there is a way to justify that initial deployment of the taser. And even after the officer tases Mr. Birch does take some swipes at the taser, and it looks like even at the officer himself. Again, none of this was deadly physical force. Mr. Birch was just using his hands, and it did not look like he was putting much power behind those swipes. But again, the officer is allowed to use any force if he believes he is effectuating an arrest. So that would be the other part of my argument, that the officer gathered enough information about the assault on the neighbor earlier in the day that he felt comfortable making an arrest. He was attempting to make an arrest here, so any force would be justifiable, including pulling out a gun and pointing it at Mr. Birch. So here, it's kind of a complicated situation with that officer element. It gives the officer a lot more opportunities to defend himself here in court than an average citizen would. However, looking at the situation in its entirety, it's difficult to argue that the officer was justified here. I do not think the officer was justified in deploying his taser, and I think there's an argument that he was not justified in firing the shots as well. However, if I was his attorney, I think I could make a good case for why he was justified, particularly if we argued that he was attempting to make an arrest here. Now, I'm sure something a lot of you are wondering is, what if the officer was an AOR member? Would this be covered? The way we find this out is by looking at the 3 criteria for coverage. The first criteria of coverage is he charged with a crime or reasonably expects to be charged with a crime. Now here, the officer is not currently charged with a crime. However, after the Charlotte County Sheriff's Office did their investigation, it was forwarded to the county attorney for review. So the county attorney may or may not bring a criminal charge. Once something is sent to a prosecutor for review, it is reasonable to say that you could expect to be charged with a crime here. He checks that first box. The second criteria is that the officer in good faith could assert self-defense as the defense to the crime charged. Now here, I think the officer definitely could in good faith assert self-defense as a defense to the crimes he could be charged with. So we can say here that second box is checked. Now the third criteria for coverage is, were they a member before the incident occurred? If this officer was a member before the incident occurred, that third box is checked. So if this officer was to be charged with a crime, he would be covered under AOR. Now, I want to hear what you think. Was the officer justified, or did he go too far? Let me know in the comments below. And while you're here, I encourage you to check out attorneysonretainer.us. Attorneys on Retainer is a self-defense protection program. You've already heard the 3 criteria for coverage in this video, so if you're interested, again, head on over to attorneysonretainer.us. You can also learn more about our firm, Attorneys for Freedom, at attorneysforfreedom.com. Get to know me and the other attorneys, and learn a little bit more about how we're the only law firm in the country exclusively committed to self-defense cases. And since you're already watching this video, go ahead, like, comment, share, and subscribe. Hope to see you next time. Peace.